his lordship, and in your word, Justice of the Supreme Court as he then was, and Justices Bafuboni and Badegbe, Justices of the Supreme Court. And their lordships reversed an order of a single justice and in reversing that order, the lordships made reference to the terms of this Evidence Act. And Justice Badegbe, whose decision was agreed to by the other lordships, had this to say at page 539. By the operation of the effect of the depositions made in the application before the High Court, the applicant, that is, the Respondent Bank of Ghana, is caught by Section 26 of the Evidence Act, which is commonly referred to as estoppel by own statement or conduct, as provided for in NRCD 323 in the words that follows. And he quotes what I have already quoted. And continues, since the said paragraphs 6 and 7 give rise to a conclusive presumption within the scope of Section 24(1) of the Evidence Act 1975, NRCD 323, the court which heard the application for leave to adduce further evidence ought to have come to the conclusion that the facts in respect of which leave was sought for evidence thereon to be led in the appeal had long been available to the applicant Bank of Ghana since the making of the application to set aside default judgment in the matter on 18th July 2012. And then they proceed to quote, Justice Badegbe proceeds to quote Section 24 and then says, further, in our view, as the application to the trial court was prior in making to that made to the Supreme Court for the purpose of obtaining leave to adduce further evidence in the appeal herein, the inconsistency between the two depositions must adversely affect the credit to be placed on the subsequent deposition, and so on. So, my Lord, the point that I'm making respectfully is that in this decision of the Supreme Court, your lordships determined that statements in an affidavit that had been filed in respect of these proceedings established a conclusive presumption which could not justify exercising a discretion to grant leave to adduce evidence. Now, in this case, we're saying by parity of reasoning that we have a situation where the chairperson of the first respondent has in affidavits made clear that the petitioner would in no way be prejudiced because the questions that the petitioner sought to have in interrogatories, those questions could be the subject matter of cross-examination. And my lords, obviously by that time, she had filed a witness statement, and she clearly intended and expressed that intention to testify. And my lords will see that in the statement of case of the first respondent, the statement of case filed by first respondent in opposition to the application for review, and that is one of the attachments to our application, and I believe that it is marked yes, it is marked recall Yes.
Mr. Chikata.
Yes, my lady.
Kindly clarify something for me.
Yes, my lady.
You want to reopen your case for the first respondent to testify as a witness?
My lord, not the first respondent. We want to seek to reopen our case. And my lords, as I indicated, we are not seeking leave to serve a subpoena. The serving of a subpoena or the right to serve a subpoena is provided for under Order 38, Rule 10. The person that we intend to serve the respondent, to serve the subpoena on, is the chairperson of the Electoral Commission, the returning officer. That person is not the same as the first respondent, evidently. But that is the person that we intend to serve the subpoena on. It's not on the first respondent.
All right, so she is coming to testify in what capacity?
She's coming to testify on the basis of the subpoena.
But you
She's
said...
coming to testify on the basis of the subpoena because she's a public official. Milady well knows that subpoenas are very often used in the context where, for instance, a public official who may not wish to be identified as testifying, so to speak, as a witness of one party or the other, but who can be subpoenaed so that in their independent capacity they can bring to the court matters which are relevant to the determination that the court is making. Subpoenas are generally set.
I asked this question because of your paragraph. Paragraph 15.
15.
Yes.
1-5. Yes.
Yes. He said, as a result of the ruling of the court of Thursday, 11th February, it has become necessary, I'm advised and verily believe that my counsel use the subpoena powers of the court under Order 38 Rule 10 of CI 47 to compel the attendance of the chairperson or first respondent to appear and testify. So you subpoena her to come and testify in what capacity?
As a witness.
Of the first petitioner.
I'm not sure in what capacity. She's a witness?
Witness of who? The court or the petition?
No, she's our witness, but as the evidence law allows, she is treated as an adverse witness, what in common law was referred to as a hostile witness.
You want to treat her as a hostile witness? If assuming your application is granted, you intend to treat her as a host?
Yes, that is what we're saying, naturally. And my lords, respectfully, at this stage, her status as a hostile witness, adverse witness under the Evidence Act, at this stage, that is not an issue before you.
No. So it's totally an issue, you see, because we have to exercise our discretion to grant or refuse your application. And we can only exercise our discretion on extremely appropriate grounds. We need to know what she's coming to do, whose witness is she going to be? And
my lords,
the capacity is important.
She is coming as a witness of the petitioner described in the evidence laws of Ghana as an adverse witness, and in common law described as a hostile witness. That is the capacity in which she is coming. When your ladyship asked in terms of capacity, I was not very clear what capacity meant. But in this context, it is as an adverse witness. That is the capacity under the laws. And my lords, I was also alluding to the statement of case of the first respondent, in which, and that is exhibited to our affidavit as part of Recall 1, and it's exhibited Recall 1. It's exhibited as part of Exhibit Recall 1. Exhibit Recall 1 consists of the affidavits in opposition to a motion or notice for review, as well as the statement of case that was accompanying that application. And in the statement of case, which I was referring to, counsel states at paragraph 4, the petitioner does not suffer any injury to his rights if the application for review is refused, as he still has the opportunity to solicit the same answers during cross-examination, unless it is his case that he does not have the full complement of his case and needs the answers to fill in. So here is counsel for the first respondent stating clearly that we do not suffer any injury. The petitioner does not suffer any injury to his rights if the application is refused for the reasons that are given. And that is exactly what Mrs. Mensa herself states in her affidavit. So, my lords, if on the basis of that position that we found ourselves in, where there had been clear representations that this person was actually going to come and be available for cross-examination, it was within our rights to rely on that representation, which has, even under the terms of Section 26 and Section 24 of the Evidence Act, been determined to be a matter of conclusive presumption. And my lords, the reason I sought to separate this stage, where we are simply applying for leave to reopen our case, from the stage of the subpoena, and your ladyship is entirely right that you do want us to be candid with you about why we are going to subpoena her, so that you can exercise your discretion appropriately, and I fully understand that. But the distinction that I wish to make, just for the sake of clarity, is that once, if your lordships grant us leave, and we filed a subpoena, which is then served on her, that is not the end of the matter, because it is still open to her, for instance, whether for human rights or any other reason, to make an application to the court and say, I should not have to come and be cross-examined or be treated as an adverse witness. She would do that by invoking a witness privilege of some sort. And, my Lord, that is a process that your lordships are very well aware of. It's a process that was described quite fully in the Supreme Court in a case called Tsatsu against the Republic. 2011, one Supreme Court law report at page 1. And the Supreme Court there goes into the issues of how a particular witness raised a claim of privilege and how it was dealt with in the courts below, and the Supreme Court then deals with that. So we are clear in our minds that indeed it will be within her rights. I mean, protection against self-incrimination or whatever it is, it would be up to the witness to make that claim and put it before the court. And naturally, the court would, as happened in that case that I have referred to, the court would hear what we have to say. In that particular case, the lower courts actually allowed the witness a privilege, or an immunity rather, an immunity in that case. And the Supreme Court overruled the lower courts and said that that claim of immunity was not well grounded. So it will be open to her to take whatever step she felt appropriate. But my lords, in our respectful submission, this is a witness who in fact has every reason to accept a subpoena and to come and testify in order to vindicate herself and her role. This is a witness who has every reason to do that. Of course, it's her judgment as to what steps she takes, but I wish to submit respectfully that this is a witness who has every reason to vindicate her role and her office by coming to testify in these proceedings. My lords, as we have previously indicated, this is a witness who gave glory to God for what she was doing. And appropriately, in our view, it would honor that God that she gave glory to in making her purported declaration, if she would come forward as a witness of truth.
Yes, the application.
My Lord, the statement I'm making is I would honor that God if she would come forward as a witness of truth.
But Mr. Chikata, you know the exercise has a purpose. Everything we do in court must have a purpose.
Yes,
and
the purpose,
excuse me please, must have a foundation and must have a premise, must have a purpose, must have an objective.
Yes.
So our only interest, and now when you talk about speaking the truth, etc., totally at large, our interest is the focus direction. And what is your focus direction? That's what we are interested in. Or you don't think we should be interested in focus direction?
Milady, it is not at all at large.
All right.
Because, milady, in these proceedings, counsel for the first respondent, obviously on the basis of instructions from her, has challenged the truth of witnesses that we have put forward and the account that they are giving of interactions with her. Counsel has challenged the truth of what those witnesses are saying. In particular, in the case of PW2, Dr. Pesa White, counsel incessantly put to him that the accounts that he was giving of why they left, why he and PW3, Mr. Metal-Nuno, left the premises had to do with instructions that they received from her. Counsel challenged this. Counsel challenged the truth of what the witness was. The witness several times had to say, but why would we leave our bags there? Why would we do that? You know, if this was not the case, why would we do that? And counsel for the first respondent put to him that he wasn't there in the meeting. Then we had Mr. Metal-Nuno also come to testify. So, my Lord, the truth of what happened in terms of these interactions that took place on the 9th of December before the declaration, the truth is essential. And it would honor the God that she serves and she glorifies if she would come and testify as to the truth. That's what we're submitting.
Can we just limit ourselves to the affidavit? Let's limit ourselves to the affidavit in support of your application. Limit ourselves to the affidavit. Let's limit ourselves to the affidavit.
In the affidavit, we have made quite clear that this truth is very crucial. We've made it very clear.
But as to the God that he serves and all that, I think that we should not.
My Lord,
I don't think it is appropriate.
Lord, that was in a declaration that we can all take judicial notice of. I mean, and my Lord, I do not say that in a light vein. I do not say that in a light vein. I say that actually in a vein of solidarity with giving glory to the God that she serves. I say that in that vein, not lightly at all. And I say that that God is a God of truth. And it would honor that God if she would come forward to testify to the truth. And my lords, in the affidavit, in paragraph 21, furthermore, in the proceedings to date, counsel for first respondent has challenged the testimony on oath of my witnesses, including testimony provided by PW2, Dr. Pesa White, Dr. Michael Pesa White, that Mrs. Jinadukwe Mensa had in a meeting with PW3, Mr. Robert Joseph Metal-Nuno, who also testified as PW3, sent the two witnesses who were serving as my agents at the National Collation Center, popularly referred to as the Strong Room, to go and deliver a message to me, with the promise that she would have a dispatch rider go and escort them back before she would make a declaration. Now, that's a matter on which that's a matter on which hearing her address the truth of that is important, because as the affidavit goes on to say in paragraphs 22 and 23, counsel could only challenge the witness's testimony.
I won't record you the specific paragraphs you are.
Paragraph 21, and then now I'm moving to paragraphs 22 and 23.
I thought you stated earlier that the process should be divided into two, and that at this stage we are really dealing with whether the petitioner should be granted leave to reopen his case. I think it would be advisable if we stick to that one. If that is granted, then we could deal with the issue of subpoena and the truth and all of that. So I think it would help if we stick with the distinction that you yourself drew earlier. We should limit this to whether or not you should be granted leave to reopen your case.
My lords, I am grateful for that indication. Suffice it to say that I moved a little bit beyond that premise because of the issue of the discretion, the basis on which your lordship will exercise the discretion. And so we have, in all candor, to put before you what we are going to do if you grant us a leave. That's the only reason. And then when the issue of...
I think
that's sufficient. Very well, very well. My lords, we will be guided by... And I mean, I'm pleased to see that your lordships agree with the distinction that I made in the first instance. Because, my lord, indeed, my respectful submission is that at this stage, there is a sufficient basis from the circumstances that arose on, I believe, the 9th of February when we closed our case. And when there was the expectation that the chairperson of the first respondent would actually come and testify on behalf of the first respondent. And my lords, I believe it goes without saying that on that day, your lordships, the Chief Justice himself, expressed some surprise at the turn of events, and for that reason asked us to come back the next day in order to address your lordships fully on the legal issues that arose. So, my lords, taking the cue, I now proceed to respond to the affidavits in opposition that were filed apparently yesterday with some Valentine's Day messages to us. And my lords, in the affidavit of the first respondent in opposition to this motion, it is my respectful submission that there is unfortunate confusion as regards what the issues in this application are. That confusion includes claiming that we are here trying to review or appeal against the ruling of the 11th and so on. My lords, we're not here for that purpose. We've intimated that we are filing a review application as well, and we are within our rights to do that. But we're not here for that purpose, as suggested. And there are various claims which I do not wish to go into, because claims about vested rights which your lordships pronounced on and so on, which, I mean, frankly, are wrong. Your lordship did not, to my hearing, talk about vested rights, and I've gone over the ruling several times. But, my lord, the most startling passage in this affidavit in opposition is a passage in which the chairperson says something to do with disqualification. My lords, I wish to quote the exact words of that passage. Yes, that's what I want to refer. That's what I wish to refer to. My lords, this is paragraph 24. Paragraph 24. Again, I am advised that a subpoena is issued to a person, not to a party, to testify for the party on whose behalf it is issued. First respondent is a party and disqualified, and so am I. We take it a bite at a time. First respondent is a party and disqualified, and so am I. My lords, the rules about qualification to be a witness are provided for in section 58 of the Evidence Act, as well as section 59. Section 58 reads quite simply, except as otherwise provided by this decree, every person is competent to be a witness, and no person is disqualified from testifying to any matter. My lords, I shudder to think where she got her disqualification from testifying as a witness from. First respondent is a party and disqualified, and so am I. My lords, section 58 does not make that possible. Section 59 goes on, and that is a section about disqualification. So perhaps we can look for some guidance. A person, 59.1, a person is not qualified to be a witness if he is A, incapable of expressing himself so as to be understood, either directly or through interpretation by one who can understand him. I don't think we have any doubt that the chairperson is a person who is very capable of expressing herself so as to be understood. Then B, and I just read the beginning again. A person is not qualified to be a witness if he is B, incapable of understanding the duty of a witness to tell the truth. My lords, if any witness or anybody wishes to rely on that on behalf of the chairperson, they are welcome to do so and to claim to this court that she is incapable of understanding the duty of a witness to tell the truth. But these are the disqualifications mentioned in section 59. The final one, which is 59.2, a child or a person of unsound mind is competent to be a witness unless he is disqualified by subsection 1 of this section. So even a child is competent to be a witness unless disqualified under those provisions. So, my lords, I cannot imagine what this basis of disqualification that is so brazenly thrown in our face in paragraph 24 is about. And it goes on even more remarkably a person subpoenaed is punishable by committal. What does that mean? I mean, a person who is subpoenaed is not punishable just by being subpoenaed unless they don't tell the truth. If they don't tell the truth, then of course they may face some consequences. And then finally, I am advised that the decision of this court renders the proposed subpoena irrelevant. My lords, with the greatest respect, my lord, not only is it a question of law, the point I'm making is that those claims about committal and so on, they arise in the second stage that we are talking about, in the second stage, not at this stage. And therefore, your lordship should not countenance what is in the affidavit.
But Mr. Chikata,
yes,
is it your proposal that we should rule on this quote-unquote first stage before you submit your you bring your submissions on the second stage?
No.
Is that your proposal?
No, my lady, that is far from my submission. My submission is quite simple. We are asking.
So you're presenting everything, are you not? You are
to the extent that I'm guided also by the...
Because you brought an application, and we must give one ruling on the application.
Absolutely. I don't expect more than one ruling. And all I'm saying respectfully is that I'm also guided by the cue from the bench that there's there's no need perhaps to go into all the issues related to the exercise of your discretion to the extent that they have to do, with what the testimony is going to be about. I mean, I take that point, that in terms of what the testimony is going to be about, it would not be appropriate for me to start going into all the details related to that, even though they are going to be important, and they are important parts of your exercise of discretion, but we have set them out in the affidavit sufficiently, and I've decided I will not go into that into too much detail out of deference to the cue from your lordship. So, my lord, I'm not expecting two decisions. I'm fully expecting that there will be one decision, and I'm saying with the greatest respect that if that decision enables us to reopen our case, what we intend to do is to file a subpoena. That is all. That is basically, what brings together the two elements of what I'm submitting, that we will file a subpoena. And at that stage, whatever ground of disqualification she wants to bring forward would be a separate matter. I cannot be arguing about the ground of disqualification at this stage. I just draw attention to the fact that in her affidavit in opposition, she seems to be talking about some ground of disqualification which is not consistent with the laws of evidence of this country. Now, before moving on to the affidavit in opposition filed by the second respondent, I am bound to draw your lordship's attention again to just a couple more paragraphs of the first respondent's affidavit in opposition. That's paragraph 23, where she says, I am opposed to the petitioner being granted leave by this honorable court to reopen a case that he closed of his own volition and without compulsion. I am advised that even if this court grants leave for the petitioner to reopen his case, it ought not cause a subpoena to issue against me because a subpoena is issued with coercive effect. Again, this is a total misapprehension of the operation of Order 38 Rule 10. Because we are not asking you to cause a subpoena to be issued against her. That's not what we are here for, as I've stated quite clearly. All we are here for is to ask for us to be allowed to reopen our case. And my lords, in paragraph 17, the chairperson says, the petitioner entered into the contest herein, believing that he would testify if need be. It became clear too soon that the petitioner's case drifted into departures from the strong room by the petitioner's agent of his own volition, and grievances that I had served tea without biscuits to the petitioner's agent who had left the strong room to be in my secretariat. Well, I mean, the evidence in question came from cross-examination by counsel for the respondent. And to talk about grievances of being served tea without, my lords, respectfully, that is such a lack of truthfulness in terms of how the evidence came in. PW3 did not express a grievance that he had only been served tea and not biscuits. PW3 did not express a grievance. He was asked a question and he answered very truthfully. Yes, I was served tea, but there were no. I mean, but my lord, for the chairperson to descend into such triviality, which was brought on by cross-examination of her own counsel, that just shows the depths to which she has sunk.
My lord, the greatest respect.
Excuse me. Mr. Chikata, the practice is that you lawyers draft affidavits for parties, deponents in general, whether he's a party or whoever, yes, in applications. So please don't let us go that far. It may be councils.
Beyond that, Mr. Chigata, I would advise that you withdraw that statement. It's not.
My lord, I withdraw the statement about the depths to which she has sunk. I withdraw that statement. And in place of that statement, I would respectfully say, very well. My lord, just to say that a paragraph like that does not suggest an adequate understanding of the issues which we raise in this application. Just to say that, and I'm sorry that I used unduly strong language. And I apologize to the person of the chairperson of the first respondent. Now, my lords, my point, however, is that this affidavit of the first respondent rather than seek to offer your lordships a reason why you should not exercise your discretion to allow us to open our case, this affidavit only resorts to attacking our case, unfortunately. That is all it does. And I need not read any more passages to make that point. But I just draw your attention to that and avoid being provoked into comments that will get me into trouble. My lords, the affidavit in opposition, that second respondent has also filed, is from Kweku Esrifi, a lawyer. And my lords will see that in paragraph 12, the deponent says the instant application does not raise any new matter of relevance which could not have been discovered by diligent effort and so on. All the, my lords, this is not, we are not asking for leave to adduce fresh evidence. That's not the purpose of this application, in the sense that we're not asking to adduce fresh evidence in the sense that you do in an appeal scenario, where as a matter of discovery of new facts, you put before the Court of Appeal that we have found new facts and we're coming. That's not the nature of application. The nature of application is, very precise. It is to reopen our case on the basis that we acted on the basis of certain representations. In our view, the chairperson of the first respondent was not even entitled to resign from those representations, but she appears to have done, and we are simply saying that we wish to reopen our case for the purpose that we have intimated to this court. And my lords, it is our respectful submission that the first respondent and his chairperson should in fact be the people who, on account of a community of interest with the Constitution of the Republic, would jump at the opportunity to come and give an account of their stewardship. The first respondent and its chairperson should be the ones who would want the world to know that they exercise their stewardship in accordance with the Constitution, by reference to due process, because there are allegations of lack of due process. And there is even evidence from cross-examination by counsel for the first respondent. There is evidence that he brought in about vote padding, for instance. There is evidence which he brought in about material on the pen drive that was in evidence from the petitioner's first witness, which testified to vote padding. Now, my lords, indeed, before I conclude my submissions, we respectfully would ask that we play the videotape which we have put in evidence of Mr. McMenu indicating very clearly that in his view, not in his view, just indicating very clearly that when they come to court, there will be testimony about vote padding in favor of the petitioner. Now, my lord, the reason why this is really rather critical is because we would imagine that this chairperson of the first respondent would want to disabuse the minds of the people of Ghana of any suggestion that there had been such grave malpractices in the context of the election that she supervised. And my lords, we have her testimony. Well, I'm sorry, not her testimony. We have, because we don't have her testimony yet. We have her counsel putting to a witness. And my lords, clearly, when your counsel puts something to a witness, it must come from your instructions. Otherwise, the counsel is acting unprofessionally. That's what her rules say. So when her counsel puts evidence of vote padding and gets confirmation from a witness of that evidence, my lord, this is a serious matter because it affects the whole issue of the rights of voters to have a credible election with results that are declared in accordance with valid votes and all that. And yet we had that situation where counsel put to the witness